Yes, Paras, I think
Yeah.
we can start.
So let's start from the top of the page. The What we have done is we have put together a few of the judgments that are important here, and we've sort of juxtaposed them in context of what the provisions of 1111B say. We will for now let's first see the provisions. Then we'll go into the case law and we'll see how courts have read into these provisions. So I think we'll only be able to cover a few judgments. We'll do one more session for the rest of them. By then you will also have a fair idea. You can also go through them in a little more detail. But let's start with section 11. It says functions of the board. So as we had seen on the last occasion, I'll just recap quickly. The SEBI Act provides for the establishment of a board called the Securities and Exchange Board of India, where there is a board which sort of consists of the chairman and a few members, and then there are various officers in the organization structure. Now, um, this this was set up primarily with a view to ensuring that in times where there were so many instances of people violating or sort of committing offenses which were not defined at that point, but it was they were offenses which were effectively not in the interest of the securities market. Our market would not have developed or would not have been a regulated sort of an organic kind of a market if the government had allowed these sort of offenses to keep happening. Just as an example, the offense of insider trading. Insider trading is a situation where somebody who has access to non-public information in relation to a listed company takes advantage of that and trades to the disadvantage of the world at large. For instance, somebody who is an employee of a listed company, say, gets information that this company is going to get a huge order, as a consequence of which its financials are going to become much better than what they are at presently. Now, this information is not in the public domain. It is not available to anyone outside of the company. But because of this individual's access to this information, he wants to use that information to trade in the securities of the company, because obviously, because once this information becomes public, there's going to be more interest generated in the company, because the financials are going to become better, and it is going to lead to a betterment of the market price of the securities of the company. So what this gentleman could do is he could start buying shares today while he has access to this information. So, for instance, today, since this information is not public, he may be able to buy these shares, say at a price of, say, 100 rupees, as an example. Tomorrow, when this information becomes public, the price could go up to 500 rupees. So, because of his having access to this information, this person benefits from the information and trades in the securities of the company. Now, obviously, if he is going to be able to sell it at 500, somebody who is buying those securities does not have that parity or the same kind of information that this gentleman has. So this is the offense of insider trading, which is one instance of what was going on in the market before SEBI was set up. So one of the purposes why SEBI was set up was to prevent, we will see that when we come to that, but was to prevent instances like these. Another instance of a fraud or a wrongdoing in the securities market could be that, suppose if two people come together and they trade between them. So what they do is that they start creating artificial trading in the script. Say one buys, another sells. After a point, another buys, the first guy sells. So without actually transferring any securities, they could be creating an illusion of trading and volumes in that particular script, as a result of which people who are watching the screen, because this is all online, there's a trading platform which is available online, people who are trading, who are watching this script, could get an impression that there is a lot of volume and a lot of demand and supply in the script, as a result of which they start buying the script. And what these two do is that eventually they sell their shares at a higher price. So this is one instance of what is called as market manipulation. So these are all the kinds of wrongdoings that were prevalent in the market, which uh, as a consequence of which the sanctity of the market, or the integrity of the market would have been affected. So therefore, what the law has done by virtue of this SEBI Act is to create a body which will effectively curb these market practices and regulate the market. Which is now, in that context, let's read 11.1 of the SEBI Act. It says that subject to the provisions of this Act, it shall be the duty of the board to protect the interest of investors in securities, to promote the development of and to regulate the securities market by such measures as it thinks fit. Now, just as a reminder, on the last occasion, we had seen the preamble to the SEBI Act, and we had discussed this aspect of those three fundamental principles for which the SEBI was set up. So this section effectively gives life, and this is the language used in one of the judgments also. It gives life to the reason why SEBI was set up. So section 11.1 is at the heart of this act and is the main. It demonstrates, or it gives life to the principle of why SEBI is set up. But there are certain aspects that we should keep in mind. The first is that this is a power, or this is a duty. In fact, it uses the word duty. Why does it say duty? It says duty because this is not merely a power. It is something that SEBI is required to do. Now, that is an important factor. It is not that SEBI has an option. When you say that it is my duty, it is something that a person is bound to do. So similarly, what this provision seeks to do is to fasten a responsibility on SEBI to ensure that the measures that it takes are in any measures that it takes, or any action that it takes, are in line with the principles that are set, these three principles that are set out. One is to protect the interest of investors in the securities market, and this is the primary duty. The idea is to ensure that the market as a whole is kept clean and is kept clear of those elements who are not wanted in the market. That is the purpose for which, and that is the duty that has been put upon SEBI. And the second is to develop the market, to promote the development of the securities market. What promote the development of the securities market means is that there should be a reasonable manner in which the development of the securities market happens. And I must say, to a great extent, SEBI has been instrumental in doing this to a great to its credit. I mean, the way the Indian securities market has developed. For instance, what are the systems that will have to be put in place? What are the yardsticks that will need to be complied with for any market intermediary or any market player to be able to trade in the securities market? Those are all aspects of promotion of the development of the, and by developing the market, what it will do is SEBI will enable the setting up of an ecosystem which will have that integrity where others are encouraged to trade in the market. That essentially is the heart of why this section says that SEBI will promote the development of the securities market and to regulate the securities market. Now, regulate means there are two aspects of regulations. One is to prescribe those guidelines or those laws which they sort of supply the rule of the games, where they tell people what is it that you need to comply with for you to be able to trade or to participate in the securities market. And the second aspect of regulating the securities market is to ensure that those regulations that are in place are put in place effectively, or they are complied with by parties. We saw on the last occasion where the Supreme Court said that the division of powers has sort of been taken away by virtue of this act. So we see that happening here, because when the aspect of regulation of the securities market comes into play, it is from both perspectives. One is to ensure that there are rules of the game, and second is also to ensure that those rules of the games are complied with. So that is what the aspect of section 11(1) entails. Now, it is important to note that this is all subject to the provisions of this act. Like we saw that because these powers are so wide in their amplitude, it is possible for SEBI to, sorry, just sorry. So uh, any action, any measure that SEBI takes, it has to be subject to the provisions of this act. Now, why is this also brought in? The reason is that the SEBI Act is a self-contained sort of a code, which has various provisions which allow an inherent kind of balance of power. So, for instance, where there is a power to set out regulations, that power also has to be exercised subject to it being cross-checked by the parliament. Where there is a power to issue directions or pass orders, that power is also there is a check put in place by virtue of having a appellate tribunal in place. So the reason why the section says subject to the provisions of this act is to ensure, and Justice Achyutan has put it quite eloquently. We'll see that in one of the judgments that we see. Earlier, there were orders. There are a lot of judgments which said that the power is of the widest amplitude, but Justice Achyutan has sort of read through this, and he says that no, the power is curtailed by the provisions of the act. It is not that SEBI can do anything that, and I mean, this is a natural corollary of any provision, any regulatory provision. The general law on the subject, as laid down by the Supreme Court, is that wherever you have an authority set up under a particular provision, the power of the authority cannot exceed its parent act. It cannot exceed its power outside of what its act allows it to do. And this is a very general proposition in law any which way, but that is further enumerated. It just shows how well these provisions were thought through, and when they were drafted, that everything was sort of taken into consideration. And over years, of course, there have been amendments and there have been changes, but by and large, this heart of the SEBI Act has remained the same. You see, there has been no change to Section 11. The drafters of this particular provision have had such a wide vision, and they have been able to put it across so nicely that this sort of remains as it is till date. Are there any questions or doubts on this? Then maybe we can take it for now. Then we can move forward.
Any questions, guys? We can go ahead.
Okay.
No
So
question.
the second part of this provision is what are the kind of measures that generally SEBI can take. So the section 2 starts with without prejudice to the generality of the foregoing provisions. The reason why this is provided is because it is not meant for the powers of SEBI to be restricted only to the measures provided in 11.2. The idea always has been that these are only indicative measures. Some of the measures that that are sort of provided for when they are talking about 11. It's like, when you say that, look, I'm giving you this power. They could have just left it at 11.1 and said, look, this is the power that you have, and within that power you can do whatever you want to do, as long as you comply with the four corners of the act. But the reason why 11.2 was brought in was to give enumeration of what was foreseen as what are the kind of measures that SEBI could take to further its mandate under 11.1. Now, the first measure is regulating business in stock exchanges and any other securities market. Now, the reason why it says stock exchange and any other securities market relates back to the definition of securities under the SCRA. As we saw on the last occasion, SCRA defines securities, and that is the provision under which the four corners of what are the instruments that SEBI gets to regulate, what is the market that SEBI gets to regulate, comes through. Now, one of them is stock exchanges. So anytime that, and the setting up of a stock exchange is also empowered under the SCRA. So the SCRA has specific provisions providing for what is a stock exchange, what is the sort of recognition that a stock exchange gets, what is the sort of regulatory mechanism that a stock exchange needs to comply with. So that is the business in a stock exchange. Now that power, the power to regulate the business's stock exchange, is what is prescribed under 11.2. And that is the measure that has been provided for. Even when SEBI is regulating the business and stock exchanges, because it is without prejudice to the generality of 11.1, what SEBI will have to keep in mind is these three objectives. So anytime that we read any provision of this act, we have to keep these three perspectives in mind. So when SEBI is regulating the business and stock exchanges, it has to ensure that it protects the interest of investors, it promotes the development of stock exchanges, and it regulates the stock market. So that is the way that these provisions are read, and they will continue to be read like that. It also says any other securities market. So while stock exchanges are one form of a market that are set up and operated under the SCRA and the SEBI Act, there could be other markets, like there are over the counter sort of exchanges for securities, or there are outside of the recognized stock exchange, there may be a trading platform that may be allowed for specific securities, etc. Then even for those securities, the regulation of that market will come in the hands of SEBI. So that is what is entailed under 11.2a. The second is registering and regulating the working of various market intermediaries. Now, just to sort of give you a broad perspective of market intermediaries, in a stock exchange, we've all heard of terms like stockbrokers and share transfer agents, bankers, etc. So these are all players in a market who carry out specific functions in the market. For instance, a stockbroker is an entity that will allow you access to trading on a stock exchange. The way that the regulations around this, the way it is framed, is that a person can't go and trade directly on the stock exchange. So a stockbroker is kind of an intermediary who has a platform, who as an agent allows trading by clients on the stock exchange. A sub-broker is an agent of the stockbroker. That is sort of sub-brokers have sort of been they are not that prevalent anymore. but essentially the one class of brokers is stockbrokers. Those are the most prominent and the most sort of dynamic market intermediaries who have the most functioning in the market because of the nature of the market, the manner in which the market is structured. No one can trade on the stock exchange without availing the services of a stockbroker, which is why a stockbroker is one of the most important intermediaries in the securities market system.
Yeah, and
Then
Paras, this is also just to add, this is also, guys, from the perspective where we discussed why SCRA also came into place. But SCRA also was to prevent manipulation by association of persons, right? So these stockbrokers only used to be those association AOPs who used to who were the center point in terms of trading, right, Paras? So I think uh,
yeah, see,
this,
the idea always has been that when you have an exchange, there are two aspects of, just to sort of go into a little more detail, since you guys have covered this, it gives me more confidence to go into a little more detail. What happens is that there are two essential functions that happen on a stock exchange. Now, if if you look at it from a very simple perspective, what happens is that suppose I as an investor wants to trade in some shares. What I can do on the exchange is that the exchange provides to me, and now it's an online platform. Earlier it was there was a floor on which trading used to happen, but now there is an online platform on which I can enter my order, where I can say that I want, there is a particular form in which I can trade in that particular script, where I can say that I want, say, 100 shares of Reliance. Now, what the stock exchange does is that it is a meeting place of buyers and sellers. So somebody who wants to sell 100 shares of Reliance, the stock exchange is the platform on which I can get a buyer for I can get a seller for my want of buying those shares. Now, so therefore, the first thing that happens on the stock exchange is that it is a meeting place for buyers and sellers. That is the first function that a stock exchange undertakes. The second related aspect of it is that it enables price discovery. What is price discovery? As a buyer, I will always want my shares at a lower price. As a seller, I will always want to sell my shares at the highest price. Now, somewhere the trade has to happen. So what will happen on the exchange, on the exchange's mechanism is that people will put their buy orders and there will be corresponding sell orders. Obviously, those who are placing sell orders are parties who have in their possession these securities. So when they place their sell orders, they will indicate on that what is the price and what is the number of shares that they want to sell. When the buyers place their orders, the buyers will indicate what are the number of shares that they want to buy and what is the price at which they want to buy. The exchanges mechanism will enable the meeting of these two. So it enables price discovery. So those are second function of a stock exchange is price discovery, because otherwise there is no way for one to find a counterparty and to decide on the terms of this of the transaction. What the exchange does is that through its trading mechanism, it allows parties to fix a price at which a trade can happen. So in every instance, so those buy orders and the sell orders depend if they match. By match, I mean if the price matches with the seller's price matches with the buyer's price, that is when a transaction goes through on the exchange. So when we say we are trading on the stock exchange, in very simple terms, what we do is there is a platform for me to match my trades with that of a counterparty. And while matching these trades, the mechanism itself determines what the price of that script is. So for instance, if there is a lot of demand for Reliance securities, So what buyers will do is they will keep placing orders, say at 10 rupees. Now they realize that there are no sellers coming forward, which means that there are no trades happening for 10 rupees. So what the buyers will do is they will up their price and say they will place an order at 50 rupees. Now, if there is a seller who is willing to sell at 50 rupees, he will place an order of sell for 50 rupees, which will match with the buy order of the buyer, as a result of which the price of that security, which that is traded right now, is 50 rupees. So therefore, what the exchange mechanism enables is price discovery, which means that this script is worth 50 rupees. People in the market are willing to exchange these shares for the price of 50 rupees basis what you can see on the, and this is all available to the whole market. It's a screen, it's a computer screen on which this trading happens. So that is how price discovery happens. And people also know that how many shares are being traded. So for instance, in Reliance Securities, there is a, say, people are trading tens of thousands of shares or lakhs of shares, because that's the kind of churning, that's the kind of demand and supply that is available in the market. In, say, another script, the trading may not be substantial, it may be slightly lower, or it may be substantially lower, or there may be no trading. There are so many scripts where for years on end there is no trade that happens. There, like, hardly once in a while there'll be a trade here or there, and that too at a very low price. So the marketplace, the stock exchanges mechanism, is firstly a mechanism for buyers and seller to meet. Secondly, for price discovery to happen, for volume discovery to happen, for people to know what is the kind of interest or buzz that is available in a particular security. And the third and the most important function that an exchange undertakes is clearing. What clearing means is that people who have now traded on the exchange acts as a counterparty to both these parties. So the guy who has sold his shares, he essentially transfers his shares to the exchange's clearing corporation. And through that clearing corporation is the counterparty for the seller. So essentially, for an actual transaction, the transaction never happens between two parties directly. Through on a recognized stock exchange or on a regulated stock exchange, clearing always happens through the clearing corporation of the exchange. So these are the three important functions that the exchange sort of enables in the securities market. And all of this, for a buyer to be able to buy and a seller to be able to sell, all of this is effected through a stockbroker. Because without a stockbroker, that is what SCRA provides, that without a stockbroker, unless it's a spot delivery contract, the contract itself is not valid in securities. So through a stockbroker, you can essentially trade on the market. The stockbroker is registered with the stock exchange. So every stockbroker will have a particular registration with a particular exchange, which is a license for the stockbroker to set up his platform for enabling its clients to trade on the market. So that is the function that a stockbroker undertakes. Is there any doubt or query till now? Then we can cover that.
Yes, Sanjay.
Sir, can you please explain the clearing part again? I didn't completely understand it.
Okay, yeah, sure. So see, what happens is, suppose if, like I said, you understood the part of the trades matching, right? The matching of buy and sell orders. You understood
Yes,
that
sir.
part?
Yes, sir.
Okay. So suppose I have bought 100 shares of Reliance at 100 rupees, example. Okay. Now, there is a seller. Obviously, I am able to buy on the exchange because there was a seller who had 100 shares who wanted to sell his shares on the market, and he decided to sell it to me for 100 rupees. So both of us have come together and our trades have matched, our orders have matched on the stock exchange. Now there is a transaction which has fructified where I am buying 100 shares of Reliance at 100 rupees, and seller, say Narayan is the seller, Narayan is selling those shares to me for 100 rupees. Now what happens is that the stock exchange's mechanism is an anonymous system. It's not that I will know that Narayan is my counterparty. I will never know who my counterparty is. I will only know that my trades have matched to this extent with someone. I don't know who that someone is. So what clearing, the function of clearing trades, what it entails is that Narayan now has to deliver these shares to me and he has to receive the money from me. So what Narayan will do is he will transfer through his stockbroker, he will transfer these shares to a clearing corporation, which is an arm of the exchange. And therefore, as far as these shares are concerned, the shares that he has sold, while he has sold those shares to me, the manner in which the stock exchange mechanism is set up is that I am not the counterparty for the purposes of getting these shares from Narayan is concerned. The counterparty to his delivering the shares is the clearing corporation. So he has to deliver the shares to the clearing corporation. And what the exchange will do is that, or what the clearing corporation will do, is that it will serve as a counterparty to me for me to get these shares. So the shares that Narayan has given are given to the clearing corporation of the exchange with the exchange as a counterparty. And what I have done is I have bought these shares from the exchange. It is a legal fiction created or an operational fiction created to enable smooth settlement. Because if it were to be done directly, then there would be chaos in the market. Suppose if he fails to deliver, then what is to be done? Things like that. So what this system does is that it ensures a free flow from an operational standpoint of transfer of securities and funds between counterparties. So for enabling that, they have set up a clearing corporation which undertakes clearing of the trade. Similarly, now when I have to deliver the monies for my trades, I will transfer the monies to the clearing corporation with the clearing corporation as the counterpart, and the clearing corporation will then transfer it to Narayan. What a stockbroker does in between is it provides a platform for me and to another stockbroker, or the same stockbroker may provide a platform to Narayan for them to have access to this system of the exchange. Both systems, one is the trading platform and second is the clearing corporation. The broker, just to sort of zoom into the function of a broker a little more, what the broker is required to do is, and that's the way that the system is set up, that the broker is required to ensure that he maintains enough margins in case one of us defaults. So when Narayan is trading in the market, when he is wanting to sell the shares, the broker will ensure that he has enough shares or margin so that tomorrow, if this particular transaction is to go through, the broker has enough margin to meet. It's like an advance. Basically, a margin is like an advance. It could either be in the form of monies like cash, or it could be in the form of other securities of other companies to ensure that the trade goes through. So the risk management system that is required to be put in place so that there is no impact of a big default, because there have been so many instances where trades have happened but parties have failed to honor their commitment. So what is to be done in a situation like this? Therefore, there is a risk management mechanism set up where the broker collects margins. He has enough advances to meet the obligations in case the client defaults in his trading obligation. So that is how the clearing and the interplay of the stockbrokers happens. Is that clear? Is there anything else that you want to understand?
No, sir. Thank you.
Okay. There was someone else also, no, who had some doubt.
Anyone else, guys? Yes, Samir.
Whether stockbrokers will have their own clearing corporation or they should match with someone.
No, so see, a clearing corporation, and those are those also are set up. If you want to understand that in more detail, there is under the SCRA there are rules, etc. And stockbroker has there is a clearing arm. They are registered. Again, there are clearing corporations and there are clearing members. So a stockbroker also undertakes the functions of clearing as a clearing member. Basically, he is someone who, like how a stockbroker has a license to enable his clients to trade on the securities market. Similarly, a clearing member is like an agent or a broker of the clearing corporation. He has that corresponding sort of a membership or a agency with the exchange for the purposes of effecting the clearing. You can read the SCRA rules, and there are specific regulations governing clearing corporations, etc. Those, I mean, if we go into a lot more detail, I think people may sort of miss the thread.
Yeah.
But
I think,
yeah,
Paras, I think that then it will digress a lot
yeah,
from what we were discussing. But guys, anyways, this is just for your awareness right now. This is something which you can read on your own, and I will also try and share some notes with you so that this entire functioning of stock market, okay, is something which is clear to you guys. So don't stress too much. Focus more on what is relevant, which is SEBI's powers, right? And yes, Sayed, you have any question pertaining to
Yes,
this,
sir.
or yeah?
Sir, it's just that not in FNO, but in normal trading, what is the need of margin? If there isn't money in my
Sayed, not at
trading.
all, not at all relatable question right now. And do you
Okay,
really
sir.
think others will be able to understand?
Okay, sir. Thank you.
When people have question on clearing corporation, how someone will understand FNO? And I've told you guys so many times not to go too much into thinking. Focus on this topic what we're discussing. You can definitely discuss with Paras sometimes in future also separately. Connect with him on LinkedIn. Don't bother him. Message him and see if he has time. But don't ask this here in this
yeah.
session.
No, so without digressing too much, just to answer Anus's question, it's very simple. It's kind of a risk management mechanism where you take an advance kind of a thing to ensure that somebody who has traded does not default on their trading obligations. So just as a broad understanding, this is how it works. Okay. So that is what the working of stockbrokers entail. Then there are share transfer agents. They are basically representatives. They are these entities that are set up specifically for maintaining records in relation to shares. So as we all know, shares are instruments. So earlier they were only in physical form. Like we must all have seen share certificates, which sort of denote that these many are the number of shares of this particular company that you are entitled to. So now they are all in demat form. Demat means instead of say a cash, the equivalent of a cash. So say if the share is a cash, the demat is essentially your bank balance, So they have been dematerialized, which means that instead of carrying physical share certificates, now you can own shares which are in electronic forms, which appear as a balance in your dematerialized share account. So that is the function that a share transfer agent undertakes for a company. So anytime that anyone wants to sort of transfer his shares, they maintain records of nomination, they maintain records of how transfers have happened, they actually physically enable transfer of shares, things like that. So that is it's called share transfer and register agent. They are all registered with SEBI and they are regulated by SEBI's regulations. Then bankers to an issue, and this maybe Narayan will explain in more detail when he's taking the initial public offering module. A banker to an issue is basically a bank that undertakes the function of enabling transfer of funds in case of an initial public offering of a company. Then trustees of trust deeds. So what happens is that in a lot of instances, in case of a lot of security, like say debentures, etc., the Companies Act provides that one has to appoint a debenture trustee for the benefit of the holders of the. It's basically like it's a trust structure where through a registered intermediary, the interest of those who hold those securities is protected. So there are specific companies, there are professional companies that undertake the function of acting as trustees of trustees. So those are also registered with SEBI. Registrars to an issue, merchant bankers. This is one of the most
All of
important.
this is something we can anyways discuss
Yeah.
at time of IPO discussion, guys.
Yeah. So
Right.
merchant bankers, underwriters also are IPO.
Yeah.
Portfolio managers, investment advisors. Portfolio managers are basically entities that will manage, as the word suggests, an entire portfolio of securities for parties. And there are investment advisors who will simply provide investment advice. So those are the types of market intermediaries, and all of these are set up under specific regulations, etc. So you can read those regulations to get a sense of. SEBI also has an exhaustive set of FNAs on Q&A on all these intermediaries. So you can read those also. Then there are depository custodians, foreign institutional investor, credit rating agencies, such other intermediaries that the board may set up. So again, these are all classes of intermediaries. Can you go to the next page, please? Up a little up. That's it. Yeah. Then there are self-regulatory organizations. SEBI has yet to set up any self-regulatory. They tried to set up one, but they haven't really set up anything. One example of a sort of a self-regulatory organization is AMFI, where mutual funds have come together and created an entity which will prescribe guidelines for the market. Now, this is important. Prohibiting fraudulent and unfair trade practices relating to securities market. So there are PFUTP regulations. If you are, these are they also make for a very interesting read, which provide for broad criteria of what a fraudulent or an unfair trade practice in the securities market would mean. So it's quite we'll cover that in a little more detail as we go forward. Promoting investors education and training of intermediaries of securities market. Now this goes in with the last two functions, promoting and developing the securities market. The idea is that investors by themselves are educated enough that, and SEBI has taken a lot of steps to ensure that there is information available on trading. There are workshops, etc., that are conducted. There's a whole lot of drive behind investor education that SEBI undertakes because it's part of its mandate under the Act. Then insider trading we touched upon a little while back. Then regulating substantial acquisition of shares and takeover of companies. This is also a very interesting and a deep subject, where basically if one wants to acquire shares or voting beyond a particular percentage in a listed company, either directly or indirectly, then there are obligations that they have to comply with, which is to ensure that a listed company does not get taken over very easily by someone. So for instance, somebody has invested in Reliance Industries knowing that the Ambani family is at the helm of affairs. Now tomorrow, if someone else were to come in and simply take over the company, then the investors may not be protected, or they may not be interested in staying in the company if the promoter or the person in management or control of the company is someone else. So these are regulations that enable investors to get an exit in a situation like that. So say if tomorrow Mr. Adani wants to take over Reliance Industries, then there are certain measures that are put in place to ensure that he has to buy back shares of those who don't want to continue in the company, and those obligations he has to comply with. So those are regulations around acquisition of shares and takeover. Then this is important. Calling for information from undertaking inspection, conducting inquiries and audits of stock exchanges, mutual funds, other persons associated with the securities market, intermediaries and self-regulatory organizations in the securities market. Now, this is an important function because a lot of times the regulator would not be able to take action if it does not have with it information in relation to that particular company. So for instance, if somebody has been undertaking trades which are in the nature of insider trading, then SEBI has to know from the company that who are the people who have access to, say, a particular type of information. So what these provisions, and this is also in context of stock exchanges, etc., that it can call for information from the stock exchanges saying that who are the people who have traded in that company. The stock exchanges are therefore required to provide information about all those who have traded in those securities for it to be able to decipher whether there has been any violation or not. So this is a power given to SEBI to enable it to collect information from, and the subsequent ones are also aligned with that. Can you go down a little, please? Are also aligned with that. It just talks of different entities. Instead of stock exchanges in the first instance, IA allows for any information from any bank or any authority or board established or constituted by any central or state act, which in the opinion of SEBI shall be relevant to any investigation or inquiry in respect of transaction in security. So for instance, somebody has traded and the details of which and monies have been say he has borrowed monies from someone for the purpose of effecting a trade. Now that the money that he has borrowed, the person from whom he has borrowed those monies may be a party to a scam, as a consequence of which this trading itself could be violative of law. Now, for SEBI to be able to put all these pieces together, it will need access to bank records, etc., which otherwise may not be available to someone. So this provision enables SEBI to seek information from banks and other organizations for the purpose of deciding whether there has been a violation of SEBI Act or not. Now, the next one also, it expands it to authorities outside of India, so whose functions are similar to SEBI. So for instance, if some entity in Mauritius has traded on the Indian stock exchange through a foreign institutional foreign portfolio investor license, now if that entity is registered with a local regulator there, then this particular power enables SEBI to seek information from that regulator in Mauritius. So that is why these provisions have been brought out. Then the next one is a general one, where for under the SCRA, anything that may be delegated to it by the central government, that SEBI can do. The next one is when they enable registration of various market intermediaries, all these registrations come with fees attached. So wherever there is a registration granted, SEBI can ask them to pay a certain fee or some charges for the purpose of this act. Then it can conduct research. For the purposes of research, SEBI has set up an institution called the NISM, National Institute of Securities Market, that undertakes, amongst other things, research also, calling for from or furnishing to any agencies such information as may be considered necessary, and the general power of performing such other functions. Now, 2A allows SEBI to inspect or sort of take on record any books, etc., of a listed company or a company which intends to get listed if it has reasons to believe that they are involved in insider trading or FUTP. Now, these are the two primary sets of regulations that provide for penal action. Why this section only provides for insider trading or FUTP and not violation of any other of its laws is because these are the two primary ones relating to market manipulation. So insider trading is also a form of market manipulation. So it will entail in its scope the entirety of any kind of offense for which penal action is required. So this enables SEBI to, if it has reasons to believe that there is a violation of sorts, to seek inspection, etc., or records from a listed company and other market intermediaries. Then the next one, can you go down? Yeah. The next one,
Paras,
sorry,
just one
yeah.
question on this.
Huh.
Do we have any instance or case law with respect to SEBI taking action against an entity proposing to get listed, which is basically after filing the RHP for fraudulent under FUTP?
Yeah. So there are a lot of instances where, in cases where companies have proposed to come out with an IPO, or if they have found instances where there is a manipulation that has happened prior to an IPO, then those are instances where there are many instances where SEBI has taken action.
But that is after company got listed, right?
But the idea is that it brings within its scope, within its power, the activities of the company
Actions.
even prior to it being
Yeah.
listed. So that one cannot argue that at the point in time when this action was taken, I was not a listed entity, and therefore you don't have jurisdiction. So the proposed to be listed part is to enable the expansion of its powers into affairs which were prevalent even before the actual listing of the securities. Okay. Now, the next one is where it says, notwithstanding anything contained in any other law for the time being in force, while exercising its powers under this, the board shall have the same powers of a civil court under the CPC while trying a suit in respect of discovery and production of accounts, summoning and attendance, enforcing attendance of persons and examining them on oath, inspection of any books, registers, and other documents, inspection of a company referred to in 2A, and issuing commissions for examination of witnesses or documents. These are basically powers available to a civil court where in course of a trial, a civil court has powers to seek information which may be relevant for the purposes of deciding a particular issue in a suit. So those are the powers that are available with a civil court, which have been granted to SEBI, basically to allow it to summon people, to enforce their attendance, to seek inspection, etc. So this is just with a view to granting a legal sort of a backup to all the provisions that are set up above. We saw that there are powers to summon and inspect and all that. To give it more legal backing, this provision was brought in 1995. Before that, while SEBI had all these powers, it did not have any legal backing, as a result of which it didn't have the sort of enforceability that it has now post 95. So that is what 11.3 does. Now 11.4 is an important one. It says that without prejudice to 1, 2, 2A, 3 and 11B, SEBI may, by an order for reasons to be recorded in writing, again in the interest of investors or securities market, take any of the following measures either pending investigation or inquiry or on completion of such investigation or inquiry. Now let's just zoom in a little bit on this one. First of all, this is a provision, this is a standalone power. So it is not curtailed when it says without prejudice to the provisions. It is not curtailed by any of these powers, because lawyers have argued in the past that, look, your powers are subject to 11.1. So what, or 11.2. So what you can't do under 11.1 or 2. For instance, we'll see in one of the cases where it was argued that SEBI doesn't have the power of recovery under 11.11.1. So how can it carry out issue a direction which is in the nature of a recovery under 11.4, which is why this section has made it very clear that it is not to be confused with all of those powers. This is a standalone kind of a power available to SEBI to do all of these things. But again, while it may do so, it has to do it by way of an order for reasons to be recorded in writing. And this is a very interesting and a very important facet of administrative law. For those of you who have studied administrative law, there are two types of authorities that are set up in the judicial system. One is the judicial authorities, or basically judges with power, who are functionaries of a court. So those are authorities who derive their power essentially from the powers available to a court of a competent jurisdiction. And the other types of functionaries are administrative authorities, or what is called as a quasi-judicial authority. Now, when SEBI undertakes its functions here, it functions as a quasi-judicial authority. What a quasi-judicial authority means is that he is not a court. He does not have all the powers of a court, and he is essentially not part of the justice delivery system of the country. He is an authority who has been granted very specific powers under a statute to adjudicate on issues relating to violation of that particular statute. So administrative law deals with this aspect, and one of the important requirements of a quasi-judicial authority is an order in writing. So for instance, judges, if they don't, say the Supreme Court sitting in appeal in an SLP, need not record reasons why it wants to reject an SLP, because it is understood that as a judiciary, as a member of the judiciary, you have the requisite sort of understanding and backing and authority of a court to even issue orders which may not be containing reasons. But that is not the function envisaged by an administrative authority. An administrative authority, by his very nature, since he does not have the backing of a court and he may not have the entire qualification of a member of the judiciary, is required to record reasons for passing an order. The reason is that that authority will have to express his mind as to why he is ruling in a particular way, so that when this particular order is being challenged before a court of competent jurisdiction, the court will have insights into why this authority has said what he has said. So this is an important facet of administrative law which has been codified under this section, to say that when an authority of SEBI is passing an order under 11.4, he may do so, but he has to keep in mind 2-3 aspects. The first is that he has to record reasons. If he simply passes an order saying that so-and-so company, in my view, has violated this, as a result of which I am passing such and such directions against this entity, that order will be violative of the rigors of this particular section, because as the constitution of that particular authority is such that he is required to state his mind and reasons why he has arrived at a particular conclusion in the facts of that case. So that is an important factor that has to be kept in mind when we are defending proceedings in SEBI, that any order under 11.4 has to meet the requirement of reasons to be recorded in writing. And we've had many instances where on particular aspects of a particular order where there is no reasoning provided, even if the order deals. So for instance, if there are 4 issues and the authority has dealt with say 2 or 3 of them and has not dealt with a particular aspect of that of the issue, we have had instances where we have successfully been able to challenge an order of that sort, and SAT has demanded the matter back to SEBI to pass an order in writing. So this is an important requirement in this. Sorry, someone was saying something.
Any questions, guys? No, Paras, I don't think.
Okay. So the other factor that has to be kept in mind again is the interest of the investors or securities market. Now, why it says so? Why does it have to repeat it here? You will see the contradistinction between this particular provision and 11.1 is that it only carries with it one aspect of 11.1, which is to protect the interest of investors. The reason it does so is because this is in the nature of operating its powers for the purposes of the securities market. So it is not meant to punish someone. It is not a power aimed at saying that you have violated these provisions and therefore I will take action against you. No, the idea is to say that you have violated and you are a party who is not someone who is necessary or who is conducive to the interest of the investors or the securities market as a whole. Therefore, I have to issue these directions. So the perspective from which these directions emanate, as far as SEBI is concerned, is always going to be the interest of the investors and securities market. If it is a standalone violation, then it is not something, and that violation does not lead to any harm to the interest of the investors or the securities market, then there is a jurisdictional gap there. SEBI cannot pass an order of that sort. It has to pass an order, and in its order justify by reasons in writing why the continuing of that person or why the issuance of that direction against that person is necessary, the discontinuation of that person, or why those directions are necessary in the interest of investors or the securities market. So what are the kind of one more aspect here is that it has to be pending investigation or inquiry or completion of investigation or inquiry. Investigation is a formal process that is initiated by SEBI for the purposes of looking into whether there is a violation, and sometimes the investigation may entail sort of collecting information and examining a lot of evidence that it has to collect across a lot of parties. So it is not always possible for SEBI to immediately conclude on what sort of violation has happened. But as long as it shows that it is in the process of investigation or inquiry, it can issue these directions. And there are judgments on this also, where this particular aspect in DLF and Boruka's case, this particular aspect was sort of looked into. We will see that when we come to the case law. So the kind of directions that it can issue is that it can suspend the trading of a security on a recognized stock exchange. Say Reliance is trading on the exchange, SEBI can issue a direction saying from tomorrow there will be no trading in Reliance, because that is in the interest of there are factors that it will have to demonstrate why the continuation of trading of that security in the market poses a risk to the securities market or to the persons who are trading in that market, in that particular security. The second is restrain persons from accessing the securities market and prohibit any person associated with the securities market to buy, sell, or deal in security. Now, this is the most used power that SEBI has exercised. What it can do is it can say that, for instance, when I gave that instance of market manipulation or insider trading, suppose SEBI gets to know that person A is engaging in insider trading. It has, through its through the stock exchanges or through its surveillance department found out that a particular person who has some close links with the company has been trading in that particular script, where there is a potential for SEBI to say that he is engaging in insider trade. What SEBI can do is it can pass an order immediately directing that person to stop accessing the securities market, which means that SEBI will pass an order saying from today onwards, you cannot access the securities market, you cannot trade any further. The reason why this sort of power is exercised is to ensure that there is no further contamination in relation to the securities market. It is basically to keep a contaminant factor out of the market to protect the integrity of the market. So that is the purpose for which the power of restraining a person from accessing the securities market. It also says prohibit. So first is restrain, and restrain a person from accessing, and the second is prohibit someone from buying, selling, or dealing in securities. So when it says prohibit, it means that a person who has the ability, who may not have traded or who has the ability to trade, SEBI can say that you will still not trade, you may not have traded. So the difference between access and prohibition is that a person who has access is already accessing the market or is already playing in the market. A prohibitory sort of an order is to keep a person saying you will not come into the market for now. So that is the power that it exercises under this section. It can suspend the office bearer of any stock exchange or SRO from holding such position. Obviously, if somebody is misusing his position in the stock exchange, or if he has carried out he's done something which sort of affects his integrity to function in the stock market, then they can obviously suspend the office bearer of a stock exchange. Impound and retain the proceeds or securities in respect of any transaction which is under investigation. Now, what it means is that if somebody has already traded and like I explained, the settlement system is in place. So what SEBI can do is that it can say that I will impound, means I will take away these securities or monies which are the subject matter of a trading between two parties. I will retain it with me, I will hold it with me till such time that I investigate and I find out whether there is an offense. Say if those two are undertaking some activity which is akin to market manipulation, then SEBI can say that these are the shares and these are the proceeds of those transactions. I will hold them with me till such time that I decide whether you have violated anything or not. So that is a power, that is an interim sort of a power given to SEBI to enable it to carry out its functioning under the SEBI Act. Then it says not attached for a period not exceeding 90 days bank accounts or other properties of any intermediary or person associated with market involved in violation of any provisions of this act or rules or regulations thereunder, provided that within 90 days SEBI has to obtain confirmation of such attachment from the special court established under 26A having jurisdiction, and on such confirmation such attachment shall continue during the pendency of aforesaid proceedings, and on conclusion of the proceedings the power of 28A, which is of recovery etc., will apply. So where there is a bank account or any other property, that attachment, see, because proceeds of a securities transaction are well within its powers, because they are all lying with the exchange, with the custodians, with the bankers, with the say banker to an issue in case of an IPO fraud, or a stockbroker. So those are easy for SEBI to attack. But a bank account or any other property is not within its powers. But therefore, to expand its powers to those sort of assets also, this provision has been brought about with the check in place that after, so it doesn't become an infinitely operating order. Within 90 days, if SEBI is not able to resolve it or is not able to conclude and pass a final order, then it has to go back to a magistrate so that there is judicial examination of SEBI's power. So at least for 90 days, it can attach on its own. That is the sort of power that has been given. Provided further that only property, bank accounts or any transaction entered in therein, so far it relates to proceeds actually involved in violation of any of the provisions of this act or rules of regulation shall be allowed to be attached. So it's not that it can attach anything at all. This is again that it has been reiterated. Of course, the section itself is clear, but it has been reiterated so that there is no abuse of this particular law. And direct any intermediary or person associated with the market in any manner to not dispose of or alienate an asset forming part of any transaction which is under investigation. This is also pretty simple. Don't sell anything, because tomorrow it may be so that this particular I may find that you have violated some provisions, and therefore those securities or those assets or those proceeds may be necessary for some sort of a action that I have to take. So please hold it with you. So the idea is to enable them to not dispose of. Again, this applies both to an intermediary and to a person associated with the market. We saw in Karnavati FinCap, the scope of a person associated with the market is basically anyone who has had any transaction in the securities market. That is the person over which SEBI will have jurisdiction under this. Provided that the board may, without prejudice to subsection 2 or 2A, take any measures specified in D, E, or F in respect of any listed company, public company not being intermediaries in section 12, which intends to get its securities listed on exchanges, where the board has reasonable grounds to believe that such company has been indulging in insider trading, FUTP, relating to the market. Sir, again, one more measure that is brought in to counter its or to curb its any abuse of its power is that after passing, either before or after passing, an opportunity of hearing should be given to the persons concerned. The next one, can we go down a little? ऊपर, थोड़ा ऊपर. Oh. No, up. We finished this. We finished
Scroll
this.
down, scroll
Down.
Yeah.
Upper, a little upper. Yes. Without prejudice to 1, 2, 2A, 3, 4, 11B, section 59, for reasons to be recorded in writing, levy penalty under 15A to 15HB after holding an inquiry. Now, can you scroll down a little? This power, I think, came in 12 or something. 31 came in 19. So what started happening is that we saw earlier that there is a power to levy penalties. Now what started happening is that it started taking too much time, where these orders were passed, and then SEBI had to appoint a separate officer in every instance, and for that officer to sort of pass orders as an adjudicating officer. So in 19, what SEBI got as an amendment to this provision was the power also to levy monetary penalty. So in addition to the directions upper, it can also now impose a monetary penalty under chapter 6A that we saw on the last occasion. Now, the amount disgorged pursuant to a direction under 11B or 12A or 19 of the Depositories Act, or a settlement under 15JB and 2J of the SCRA, so and so, as the case may be, shall be credited to the Investor Protection and Education Fund established by the board, and such amount shall be utilized in accordance with regulations made. So what this means is that there are so many instances where somebody who has violated some provision, the amounts that are sort of taken away by SEBI, which are the subject matter of that transaction, those amounts lie with SEBI. So for instance, somebody who is engaged in market manipulation, what SEBI will do is SEBI will say that from your books, I have come to know that you have made a profit of say 2 crores from these transactions. You pay these monies back. So this is called disgorgement, which means that to undo a wrong action, somebody who has benefited unduly up to the tune of 2 crores is now told that you give these 2 crores back. So when this particular provision says that SEBI has to, whenever SEBI collects monies like these by passing orders, those monies are to be kept in a particular account, in that particular fund, and the manner in which that fund is to be utilized is as per the regulations that SEBI prescribe. So that is under 11. Can you go down a little? We'll quickly cover 11B also, and next time we'll see the judgments, etc. Save as otherwise provided under 11, after making or causing to be made an inquiry, if the board is satisfied that it is necessary in the interest of investors. Now here it brings back orderly development of securities market, or to prevent affairs of an intermediary or persons referred to in 12 being conducted in a manner detrimental to interest of investors or securities market, or to ensure to secure the proper management of any such intermediary or person, it may issue such directions to any persons of class or class of persons referred to in section 12 or associated with the securities market, or to a company in respect of matters specified in 11A as may be appropriate in the interest of investors or securities market. Again, this is a broad power where it says that it can do anything under the act, under the sun, for the purpose of securing the interest of the securities market. We will see how courts have read these powers. It's very interesting. And for removal of power of doubts, it is declared that the power to issue direction shall include and always be deemed to have included the power to direct any person who made profit or averted loss by indulging in any transaction or activity in contravention of this provision or regulations to disgorge an amount equivalent to the wrongful gain or loss averted by such contravention. So, like I said, if somebody has made a profit of 2 crores or has avoided a loss of 2 crores by indulging in, say, market manipulation, then SEBI has the power, and this section says that it is always deemed to have had such power to ask that person to bring that money back. And how that money is to be utilized is what we saw under 11.4. Again, 11B2 again specifies that it can levy penalties. So that is the whole scope of 11.11B. Any questions or any doubts so far? The section is very general. All these sections have very general sort of powers enumerated. We will see next time how courts have seen these powers and how those powers have evolved over time through judicial precedents.
Right. Right. So guys, I think so for today we will hold the session because there's enough for you to revisit. Okay, what Paras has discussed. Paras, that was quite a wonderful session, boss. And any questions, guys? Anything you wish to ask? Yes, Anushka. You are on mute. Can't hear you. Yeah. We can't hear you, Anushka. There's some issue with your mic. If you want to type out, you can type out also. In the interim, anyone else? Any questions? So, Paras, these guys have exams. So I'm giving them a break of almost 10 days from now.
No problem.
And we'll be reconvening our sessions 26th onwards. So I think that will give them enough time to others at least.
I think
case
now
laws.
if they
Yeah.
see some of the case
Yeah,
law
yeah,
in light of what we have studied today, maybe it will sort of it'll be more relatable.
yeah. No, and actually these guys have already started reading quite a few of them, and they've already started pointing out the interesting stuff they are reading. Especially Khyati has pointed out a couple of interesting points which lawyers have contended.
Hmm.
So
Yeah,
she's
it's
Khyati, you can share with Paras also. He'll definitely
yeah, I will really enjoy it.
appreciate. So no, but that's the whole point. I think what Paras mentioned last time, guys, to you. Okay. The whole idea of reading judgments is that you will start liking the subject. You'll start enjoying it because there are sort of contentions which will come through, which you will see that will only pique your interest more into the subject. So, so, so I think 4 or 5 of them have started reading. Others have exams, but by then, by the time we have next session, I think we will have more interactive session now.
Yeah.
Have you messaged? Sir, could you please explain the difference between restraint and prohibition under section 11(4)?
Yeah. So, like I said, restraint is to somebody who is already in the process of having access to the securities market, and prohibition means you are restricted from entering the market. For instance, there are times when somebody is directed, there are orders of SEBI where they say that you are prohibited from taking up any directorship or any similar position in any listed company. So restraint is to say that you will not trade, or of course here the prohibition is also in context of buying, selling, and dealing in securities. But the idea is to say that you are prohibited from taking or undertaking any further activity of buying, selling, or dealing in securities. Whereas in case of a restraint, you are told that you remain. It's more of a status quo. It's not in the form of an injunction. It is more in the form of a status quo kind of an order. If you want to understand it from the perspective of powers of a court, a restraint is more of a status quo order, and a prohibition is more of an injunctive order. I think that may be more relatable.
And Paras, restraint from assessing securities market could be more of also this key, generally in any manner whatsoever. Prohibition is primarily from the dealing perspective.
Yeah.
So
That also. So it's like a status quo, which means that
Yeah.
don't engage any further. And restraint is to say, prohibition is to say that don't come in now. Any
any
other
other
question?
question, guys?
So can I?
Yes, sir.
Huh. Sir, from where the SEBI get power to issue an interim order? Like, I see it's an violation of Audi Altram Patent.
We will see. If you see the case law now, you can, if you want, you can read Anand Rathi's judgment of the Bombay High Court in the compilation that we've sent. Mr. Manu Singh, Dr. Manu Singhvi has raised this point of Audi Altram Patent, and the Bombay High Court has dealt with it very nicely. You will see that.
Thanks, sir.
Incidentally, Dr. Manu Singhvi's PhD is, from what I understand, is in the subject of these these powers of authorities without these interim powers of authorities, or in context of natural justice. So he's actually a PhD in that subject, and the Bombay High Court has sort of, despite his very brilliant arguments there, you will see he's supported it with a lot of case law, and it's a very, like Narayan just said, it's a very beautifully argued case. Bombay High Court has said no, it is not a violation of Audi Altram Patent, because there is always a post-decisional hearing that needs to be granted. We saw the the section, no, it says that SEBI has to afford a personal hearing. So it is not that it is dispensed with completely. It is only suspended in the interest of the market. The interest of the market supersedes the rights of an individual. That is the scope of powers under 11. Because without that, there is no heart to the regulator. The power doesn't exist. So the idea is to send a message through legislation and through judicial precedents that this is a regulator whose powers exceed, for a short term, of course, and subject to checks and measures, the fundamental rights also of a party. To that extent, that's the seriousness attached to the power, to the scope of the authority of this regulator. That is what it is. We'll see that. I mean, it will make for very interesting reading. I wanted to sort of create a base by reading the section together once, so that when we read the case law, we will read it in context of. These are good questions. It's good that.
And I suggest, guys, all of you should read these case laws beforehand. And specifically, if you have any question like this, right, you will have more questions for Paras before the next session, right? So I think that will only, like, now Sayed, since you asked this question, right, others also will be very curious to know what exactly it is now, right? The same ways, if you guys are well read sort of thing you have done before the next session, we have more engaging and fruitful session. We can do couple of more sessions with Paras's time. I don't think that should be an issue. It's just I want now you guys to read also. Now you have 10 days time. Read up. I think there are 12 case laws in the compilation. So read up those. Okay. And be ready with your questions also, specifically now since you know what powers of SEBI are under SEBI Act. Okay. So we will see you after a 10 days break, guys. Best of luck for your exams. Do well. And thanks a lot, Paras.
Okay,
for
thank
such a
you.
session. Thank you. Thank you.
All right.
Thank you.
Thank you, sir.
Thank you.
Thank
Bye.
you.
Thank you.